All right, welcome back. So this week we will discuss transferring property interest. We're done with the portion of the course where we actually define what the property interests are, right? So we looked at a lot of them. We looked at kind of chronologically, first how you can acquire a property interest, namely by virtue of possession. We saw that in the context of personal property, which is stuff, right? Stuff that is not land or buildings attached to land. And we saw a similar concept with adverse possession in the context of land or real property, although it's slightly different because of the registration system. Then we looked at the nature of the property interests that you can have. We saw the license at the very beginning, right, which we said is not a property interest. It's a contractual interest, and therefore there are consequences to that, right? Because of its contractual nature, it limits the scope of the rights that you have if you hold a license, also limits the scope of the remedies that you can claim, namely that generally you don't get a right to specific performance. Then we looked at the various types of interests in land, right? We looked at the fee simple, we looked at the life estate, various permutations of that, lots of permutations of that, right? These are all property interests. Then we looked at lending stuff, which is not the same as, of course, giving stuff, right? Because it's temporary. So you give someone your stuff, whether it's real or personal property, for a limited period of time, for a limited purpose, and the person, right, is supposed to give it back to you at the end of it. Now we look at, right, transferring, that is permanently, a property interest that you have, whatever it is, can be real or personal property, and again we saw the various permutations of what interest you can have in real or personal property. So, you transfer that, as we said so far, it can usually be by will or by deed, namely you transfer it when you're alive or when you're dead. We also alluded to the fact that it can be for free or for money. There's no requirement that someone actually pay for a transfer of real or personal property to occur, again, of the various property interests that we saw, right, which would exclude a license for that reason. This is different from acquiring title by virtue of possession because there is no intent. The person who lost their stuff does not intend to get it back because they don't know they lost it. The person who lost the stuff doesn't know they lost it, and they don't intend for you to get eventual title, right? It's a consequence of the fact that they don't know they lost it by virtue of the law. Nonetheless, they do not intend for you to specifically get title. They just lost their stuff. If they intended that, they would have given it to you, right? Again, by will or by deed. In which case it would be a gift, which is what we'll look at this time. So, different there in that there is no specific intent to transfer to that person, unlike in a transfer of property interest, as we will see. Also different from a bailment, of course, for the same reason. You're essentially lending someone your stuff. Again, could be for free or for money. So, someone agrees to look after your whatever it is while you're on vacation for free, or you go to a parking lot, someone agrees to look after your car for money. That's a bailment. It is different in that it is limited in time, and there is no intent for the person to acquire title at all. You're giving it to them, right, specifically by saying it is only for a limited period of time, a limited purpose, and by virtue of that, you do not intend them to acquire title. Different from a transfer of property, as we'll see this week, because in the case of a transfer, it's the other way around. You actually do intend for title to pass. That's why generally you sign a contract and you intend for that to be permanent. So this is the most common way in which you transfer property interests, right? You don't lose your stuff, you don't lend it. If you want to transfer it, you do that under the principles that we will see for this week. So, again, right, I won't repeat it. You can do that by deed or by will. A question I got, I think last week, which I apologize for omitting to specifically mention during the course, is that there is a different word for deed or will. I would have assumed that you looked it up on your own. I probably shouldn't have. If you are transferring property to someone, right, you can do that by deed or by will. If it is what we call a conveyance, generally it's by deed, namely you're alive, right? If it is willed to someone, it is what we call a devise. So if you are devising property, it implies that it's by will, not when you're alive. Of course, the nature of the will is that you sign it when you're alive, but it evidences a future intention. So nothing happens when you sign the will, right? Of course, because you can't have a present transfer of a future property interest. We saw that under the remainder rules, I think. So you can't say to A for life or to A in fee simple 10 years from now. That is the main estate that you're transferring, and the main estate that you're transferring has to be transferred presently. So for that reason, if you sign a piece of paper, it says, when I die, this person will have my stuff. That is not a present transfer of property. It is an intention now to transfer later. The transfer happens when you die. So that's why you can change your mind in the meantime, because nothing happened, right? Because the person did not acquire any interest, not a property interest, not any other kind of an interest to a future thing. Therefore, you can change your mind. So, it happens in the future. At the time that it happens, namely when you die, it is devised, not conveyed, and the language is different there depending on the nature of the transfer of property that you're trying to effect. First thing we look at in this chapter is a gift, so a transfer by gift of a property interest. Of course, again, could be of real or personal property. So, as we'll see, you have three criteria to transfer a property interest. The first one is an intention of the person transferring the property interest to do that. So they have to intend, right, first to transfer the property interest as opposed to do something else, like enter into a bailment, which is different. It's not a permanent transfer for the reasons we mentioned. So they have to intend for it to be transferred permanently and for it to be transferred, in the case of a gift, for free. Second, you have to have acceptance, as we'll see that is formally a requirement for there to be a gratuitous transfer of property. Nonetheless, it is not generally at play because there is a presumption that the requirement is met. So, what that means is that, right, until someone says otherwise, you presume that there has been acceptance, that the person who is being gifted something agrees to it, right? And unless you show otherwise, it's presumed. So formally, it is a requirement in that if you don't meet it, it defeats the gift. They are cumulative requirements. Nonetheless, right, because it's assumed, you don't have to specifically prove it in establishing a gift, because it's presumed until someone says otherwise. If someone says otherwise, right, they deduce evidence, then you have to prove it. Last one is delivery. As we'll see, this is where it gets a bit more complicated. Delivery is essentially an additional requirement because of the nature of contract law under the common law in England and Canada. Because historically, right, you could not have a contractual transfer of property for free because of the requirements of consideration in contract law, right? It had to be a mutual agreement. Mutual meaning every party gave something. If you gifted your property, it was a gratuitous transfer of property. In other words, you gave something, the other party gave nothing. That was a problem because it did not meet the mutuality requirement under contract law, which we call consideration. Eventually, the courts decided that, right, it was a bit of a problem if you defeated all gifts, right, both for policy and other reasons, therefore created a requirement of delivery. So the delivery of the gift, right, meaning broadly what it says, established the contractual validity instead of the consideration requirement. Okay, so we said these are the requirements. There is, and again, this can be done by deed or by will. If it is, and for real or personal property. If it is real property, then you need a deed. What does that mean? It means that you need a piece of paper evidencing the transfer. By default, under the common law, as we discussed, I think, last week, you do not, right? You can transfer property. There's all sorts of reasons and ways in which you can transfer property. And you can do that without a piece of paper. That is because, as we said again, I think, last week, you're transferring a property interest, not a contractual interest. So, if you have a license, we said, it's not a property interest. In other words, it's not a relationship between you and the thing, which is what a property interest is. It's a relationship between you and the other person who owns the thing, which is a contractual relationship between two people. So, license, you get to go to the movie theater for 2 hours on the Friday. That does not create a relationship between you and the movie theater in the way that it does if you rent an apartment. It is merely a contract. It's an agreement between you and the owner of the movie theater to let you show up, which is a license. Do something that would otherwise be illegal, namely be upon their property, which otherwise would be what we call trespass because you have no right to be on someone else's property. The property relationship in that case is between the movie theater and its owner only. There's no relationship between you and the movie theater. There is a contractual relationship between you and the owner. That's why you generally cannot seek specific performance. So if the owner breaches the contract, doesn't let you in, generally you cannot ask for specifically the right to come in. You can only ask for damages, unlike, say, a lease. That's the nature of a license. And the contract is important there because it is the source of the right, right? There is a right because you signed a contract, whatever it looks like, an agreement. It is also the nature of the right. The right is a right of a contractual nature uniting you and the movie theater owner. In contrast, if you transfer a fee simple is again a property interest, a relationship between someone and something. So, owner number one has a relationship to their house. It is a property relationship uniting a person and a thing. Then they transfer that to owner number two. What they transfer is, again, their property interest, a relationship between them and the thing. Transfer that to someone else, right? Then they no longer have a relationship with the thing. Owner number two now does. The contract there evidences the transfer. And it's helpful, because if you're going to pay $300,000 for something, right, you might want there to be a paper trail of this. So the contract evidences the transfer. Nonetheless, it does not, right, create the right. It transfers the right, but the right remains a property interest. It's transferred, right, between owner number one and the thing is now between owner number two and the thing. The contract transfers that interest, but the right is not of a contractual nature. It is a property interest, not between two people by virtue of a contract, rather between a person and a thing, which is now between another person and the same thing. So it's a property interest for that reason, transferred by contract. So, for that reason, the contract is not the nature of the right. It evidences the transfer, but the right is not of a contractual nature. The contract is an instrument to transfer a property right. Nonetheless, that's the default common law position. And everything I just said, which took a bit, right, is the reason why you don't normally need a contract. Because you're transferring, again, a property interest, which unites not two people, but a person and a thing, as opposed to creating a right between two people, which would be a contract. Nonetheless, in some developed countries such as Canada, the legislator has passed a statute that says that you need to have a piece of paper. So that changes the common law position somewhat. Nonetheless, it doesn't change the conceptual framework that I just discussed. It doesn't mean that now the right is contractual because you need a contract to transfer your house. Everything I just said remains true. It is merely, to be specific, a rule of evidence. It's not the government saying now there's an additional requirement. It's not the government saying now it's a right of a contractual nature like a license. It's simply the government saying we don't want to get into people going to court and trying to prove, right, the sale of a 300 grand asset verbally. We think that's inefficient. Therefore, we will require, essentially as a rule of evidence, that you sign a piece of paper evidencing that transfer. All that remains important. We discussed that last week. So, because of that, if you are transferring as a gift real property, you will need a deed. You will need a piece of paper evidencing that transfer. Again, doesn't change the fact that you're transferring a property interest, not a contractual interest. And you have the same three criteria apply. As a corollary, if it's not real property, you don't need a deed. If it's stuff, not a house, you don't need the piece of paper. Okay, then, and again, sorry, just backtrack a little bit there. The gift can be by will or by deed. It can be transferred by a will or by a deed. In other words, while you're alive or when you die, as we'll see. There's also a hybrid category, which is a donation mortis causa. Again, some bad Latin there. It's a hybrid between them because, as you'll recall, a will is different from a deed in that there is no present transfer of property. So you sign the piece of paper, your will, when you're alive. It says, when I die, this is how I want my property to pass. For the reasons we mentioned, that does not create a present interest. It can't, in fact, because of the rules, right, that we saw. And therefore, nothing passes until you die. That's why you can change your will, and no one has an interest pursuant to the will that would allow them to prevent you from doing that. So, that's the distinction. If you transfer by deed, while you're alive, you transfer it now, when you sign the deed. You sign a piece of paper that says, I hereby give my stuff to this person. Say it's, again, real property. If it's personal property, you can have a deed, don't need to. Still, it's a transfer inter vivos. It's a transfer while you're alive. You can also transfer it by will. Donation mortis causa is a distinct category in that it's related to death, like a will, but unlike a will, you have a present transfer of property. So, you think you will die. Because you think you will die, you give your money away. For example, you've got $2 million. You need it. That's how you pay for your home care. Then you realize you'll die tomorrow. And so you think, I will give my $2 million to my son now. That way, I'll be sure that when I'm dead, there won't be probate issues and people fighting in court. I'll be sure that my son actually gets the $2 million, which is my intent. Donation mortis causa in that, first, it's because you know you'll die soon, you are contemplating your death. But second, unlike a will, which is the other thing that has to do with death, you do that now. The son gets the $2 million then, before you die. That's why it's a hybrid category. And, as we'll see, it's also a different category in that it is automatically revocable. So, if you do not die, then your son will not get it. And that's because, right, essentially a matter of intent. Your intention is not to give your son $2 million under any condition, otherwise you'd have done that before. It is to do that to the extent that you die, because you made that decision when you thought you would die soon. Therefore, it's different from both in that if you do not die, it's automatically revocable. So the son has to give it back afterwards, because again, it's present. So when you give it, you give it. That's when the transfer happens, not when you die, then. So you've got a transfer. Legally, it is now held by the son. If you do not die, they have to give it back. I say give back because they got it in the first place because it was a present transfer when you try to give it. Okay, and again, this is not because of contract law. This is distinct. If you're trying to transfer something by gift, transfer something to someone else for free, whether real or personal property, you have to meet the 3 criteria that you see there. Not just offer and acceptance, because it's not regular contract law, it's the 3 criteria that you have there, namely because under regular contract law, you don't just have offer and acceptance, you also have consideration, which would essentially never be met in the case of a gift. So, contract law principles, but as adapted to a gift, because otherwise they would prevent it. Okay, then you have a bunch of examples evidencing the third requirement of delivery of the property. In recall, you have a guy who tries to give furniture to his wife. Buys a house, right? Then there's stuff in the house. He says, it's yours now. Was there deliveries? You can imagine delivery generally means what it says. You give someone something. Sometimes it's easier than others, right? So if it's a piece of jewelry, it's not that complicated. You've got a necklace, you give it to someone, right? You essentially, to go back to some stuff we saw at the beginning of the semester on lost objects, you acquire dominion over it. Physical possession, which we said, right, in a different context, of course, is evidence of title. Same thing. You have physical dominion over the necklace, you give it to someone, and that someone has physical dominion over the necklace. That's the delivery, the change in physical dominion over the thing. As you can imagine, it can be a bit more complicated than that, right? If it's a house, you don't get to lay over it. So if you give, say, the keys, and the keys are the only way to get in, it's how you transfer physical dominion over the thing. Now you've got a different issue. He's trying to give furniture to her. Of course, right? If he gives it to her, then he leaves forever, then he's given her physical dominion over the furniture. It's not what happens. He lives with her. So he says it's yours, but then it's their house, the both of them, and they both use the furniture. So there is no apparent transfer of physical dominion over the thing. In fact, he keeps using the furniture, which appears to be the opposite of what you're supposed to evidence under delivery. And long story short, right, for that reason, the court finds that the verbal declaration that you want to transfer your furniture, which of course is helpful in showing intention. The other criteria are met, right? Intention, he says it's all yours. That clearly evidences an intention to freely give her the furniture. Acceptance, we said, is presumed, right? So she says, thank you, which she doesn't even need to say. She can say nothing, right? Again, acceptance is presumed, as long as she doesn't say, no, I do not want this furniture, which is, you can imagine, doesn't happen all that often. You've got acceptance that's met. Last criterion is delivery. So the fact that he says it's all yours is not useless. It's useful in evidencing two, essentially, of the three cumulative criteria that you have to have for a gift. But you still have to show delivery, which in that case, the verbal declaration is not sufficient to show. For that reason, the gift is not valid. So, you have a comment at page 476 to the extent that essentially it's no longer necessarily good law in Canada. So, why is that? And we won't get into the specifics of that, but under the general principles, that would be the reasoning. Now, it appears that courts have been more lenient. So, the default rule would have been, again, you have to have delivery. As I said, sometimes you can have a permutation of delivery. So, it's a house, you can't show dominion over the house, the keys work. That's essentially constructive possession, because constructive meaning made up or artificial or symbolic possession, put it that way, right? Because you cannot show dominion over a big thing, usually, right? The keys help do that. There's a comment, page 476. It appears that, and we won't get into whether or not that's correct, but it appears that now it's being expanded to the extent that courts are more willing to have constructive possession by virtue of things that are lower than the example of the key, which is also control. So perhaps this example would have met the criterion under Ontario case law. And essentially, the criterion that appears to apply is that there's no other possibility. So in that example, it would not meet the criterion of delivery under the common law, but it is an odd situation where there is no way to meet the requirement, right? Unless the guy moves elsewhere, essentially. In these cases, the courts are more willing to find that it's an artificial requirement, but more importantly, an artificial requirement that cannot be met, even if you tried. And in these cases, it appears, although it's not clear, the courts are willing to find that delivery has been effected. Again, 476. Okay, then you have two cases. First, a check, right? Not that 478, not that many new principles, but essentially the same thing. If you don't cash the check, there is no delivery. Then you have probably the most confusing and useless case that you'll read this semester, which is the Thomas case, which either you did not understand or had to read 4 times over. Not that important. You have a famous playwright, I think, right, writes a play or a movie, whatever it is, right? Then it's essentially commissioned, so they go to the guy's office who commissioned it and says, I'm done. But it doesn't say I'm done for the purpose of giving it to them for free, but for the purpose of, right, negotiating the nature of the rights that will be transferred. Then, unfortunately, they lose it. And then they tell the guy who commissioned it, the BBC guy, I lost it. If you find it, you can keep it. So, changes the intent. The intent was not initially for him to get it for free, but now by saying, if I lost it, right? Because I lost it, if you find it, you can keep it. It's evidencing, potentially, a gift. The intention is to give it for free, that's what he said, right? To the extent that the BBC guy does not say, no, I do not want it, you've also got acceptance, and delivery ostensibly would be affected by finding it, right? Finding it, and therefore exercising physical dominion over it. There's a complication there in that the guy's dead. So the conversation isn't recorded where he said that if you can find it, you can keep it. And on top of that, The guy's dead, so he can't come in and testify to say, yes, I said that. So it's an evidentiary issue. It has nothing to do with the criteria, just has something to do with the way courts work. The way courts work is with evidence. If you want to show something, you have to prove it, right? It's harder to prove when the guy is dead. You've only got one witness, and you're trying to say it's true because my witness said it. And eventually, right, again, after very long, complex, and not particularly useful reasoning, the court finds, for the reason I mentioned, that you have the requisite intention in that case. And the court finds that it is not implausible. It's one of the arguments that's made by the other party. It says, the guy who talked to Thomas, right, and purports that, Thomas said, if you can find it, you can keep it, this guy is lying. We know this guy is lying because it is implausible. First, the plays or movies are worth a lot of money. Therefore, it's implausible that he would have given it for free. The court says, no. Why? Because they're worth a lot of money now that he's dead. Back then, they were worth less money. On top of that, he appears to be a generous guy, of the kind of guy that would give their stuff away for free instantly, and therefore it's not implausible. And again, right, this is different from a lost object under the principles that we saw at the beginning of the term, because although it's lost, if it's lost, right, you could have a third party, anyone find it. Then that person would find it, unlike the BBC guy, would not acquire possession over it with the consent of the rightful owner. Therefore, they would have to acquire title eventually under the principles that govern lost objects, which we saw at the beginning of the term. And it would take some time. In contrast here, it is a lost object. Nonetheless, the owner says, if you specifically, BBC guy, not anyone else, that anyone else would be subject to the lost object rules. If you find it, you can keep it. Therefore, if he finds it, he is not under the law of lost objects because he has not found it without the consent of the rightful owner. Because the rightful owner called him and gave him consent. Said, if you can find it, you can keep it. Therefore, if he finds it, it's a lost object, but it's not the law of lost object because he finds it and acquires possession with the consent of the owner. To the extent that that's true, which a court finds, right, but to the extent that you meet the evidentiary burden that you have in showing 1, 2, and 3, then you acquire title, and that's the distinction again between the loss of lost objects and this, now. Because the gift is a present transfer. It's a transfer. If you find it, you can keep it. When you find it, you keep it. That's it. You get title because the intent of the owner, Thomas, was to transfer title when you found it. Therefore, you got it with their consent. It's a gift. Again, 1, 2, and 3 are met. No deed necessary because it's real property. It's a bunch of pieces of paper, not a house. Therefore, you get title then, not 20 years or 10 years afterwards under the principles that apply to lost objects. Okay, page 483, you have, right, the circumstantial analysis that I just mentioned. So you do have to meet 1, 2, and 3. The way this works in the real world is that you have to meet your evidentiary burden. You have to show evidence in establishing whether or not your evidence is probative, whether or not your evidence is sufficient to show 1, 2, and 3, because usually, right, the other party will say the opposite, otherwise you wouldn't be in court, so you have to be more credible than the other party. You have to look at the factors, you have some there. The issue, at the very end of page 483, the issue of intention requires a court to consider the circumstances of the donor, the relationship at issue between the parties, right? If it's someone you don't know, it's less likely that you'll give them something that's worth a lot of money. The size of the gift and its relation to the total amount of the donor's property. Again, same thing, right? If you're poor, you probably don't give 100 grand away that often. Therefore, it's unlikely that someone would be able to establish that you did that, or less likely at least, than if you have a lot more money. Okay, then you have the art gallery, page 484 again. Same principles, right? Is it a bailment? Is it a gift? In that case, right, guy wakes up, I think 20 years later, starts to say that the paintings I give were a bailment, not a gift. But you have that question all the time, even at the time of the transfer. It has to be clear that something is a gift. You meet 1, 2, and 3, right? 1 is the intention, and the intention, it has to be clear, is for you to give something permanently and for free, right? We'll actually write it down, so that's helpful. I mentioned that earlier, right? It's the nature of a gift. So, a gift is a transfer of property of a nature that is permanent and for free. So, the intention that you have to evidence is that intention to have a valid gift. Sometimes a question will arise as to whether or not it is a bailment instead. A bailment is different because it could be for money or for free, but it's not permanent. You intend to give something to someone, but not permanently, only for a limited period of time or for a limited purpose. Therefore, it cannot be a gift. In fact, it's the opposite. If it's permanent, you intend to transfer title. I intend for this to be yours, for it to be yours. You are the owner, the only owner. You get to write that down in the register. In contrast, a bailment is not permanent, and the underlying meaning of that, as we said earlier, is the opposite. It's, I am giving it to you without giving you title, with the express reservation of title. If I'm giving you my car for 2 weeks, I no longer have physical dominion over it, but that is specifically without the fact that you could acquire it as you would with a lost object, because I'm specifically reserving that right for myself. Okay, then there's a very brief discussion of the McNamee case, which establishes an important principle regarding intention, and that is that your transfer does not need to be generous. So, the way we traditionally conceive of a gift is that you're trying to make the other person happy by giving away your property. The McNamee case says this does not have to be the case. So, the reality is what I said. Permanent transfer and for free. You can transfer something permanently and for free without the intent of being nice. For example, with the intent of not paying taxes. Do that by giving stuff to your kids now, right? Or when you die, you could transfer assets before you die so that when you die, they pay the taxes, you don't, which is we call an estate freeze anyway, right? There's no generosity requirement. So you could do that for a self-interested purpose, for the purpose of looking good on TV, for the purpose of saving yourself taxes, and generosity, therefore, is not a requirement. You'd still be transferring something to, say, your kids, permanently and for free. You just wouldn't do that necessarily because you're trying to be nice. So as we said, 486 is where there's a discussion that acceptance is presumed. I won't repeat that. Okay, so we'll do some erasing there. Okay, now there are, well that fell, there's a discussion of trust law. So, as we said, you have got the legal rules under the common law, so regular rules, and you have got the equitable rules under equity, because historically you had the real courts, which were the courts of law, the common law courts, which had laws. Then, because the laws oftentimes sucked, right, people had particular situations where the application of the law was unfair. And because sometimes the assumption is that the law is supposed to achieve justice, you had the courts of equity. Initially, it was a royal prerogative. You could appeal to the king. The king could waive the application of the law if it were unfair, as, for example, they do when they decide not to execute someone who was sentenced to the death penalty, for example. Eventually, the king got so many requests that he hired a bunch of people to administer equity, and eventually that morphed into the courts of chancery or of equity, which is where you went when the law did not favor you, but you thought it was unfair. We saw that in detail earlier, and that's where the trusts come from. The trusts are made up by the courts of equity. Now the trusts come back in two ways. And I'm at page 486 again. So we'll see there are two types of trusts, which essentially correct unfairness. So the court, now the two courts I mentioned earlier were merged, quote unquote. Right now in Ontario, there's the Ontario Superior Court. There isn't the Court of Equity and the Court of Law. So the Court of Law administers both law and equity. Trust is an equitable remedy and or creation. And so, constructive and resulting trusts, you've got two situations. First, when you intend to affect something, like a gift, but as we'll see most often doesn't work, but could be anything else. So you try to transfer your house, there's some very specific statutory criteria, 1 to 5, you don't meet number 5, say. But it's clear that you intended to transfer your house, or say get married, same thing. 5 requirements, you don't meet the 5th one. Everyone agrees you intended to do the legal thing, but for essentially a technicality, you did not. Then the courts of equity come in, make up something that affects that safeguards the validity of the act that otherwise would be illegal. You see that with a trust. One example is where you do not meet the requirements to transfer something legally. So my example of a technicality, for example, then the court will make up a transfer of an equitable nature, and I think make up is the correct word, that will happen. So you'll have an equitable transfer because you did not and could not have a legal transfer, but it will essentially do the same thing, with one exception, which is that it's not opposable to third parties. Other type of trust is when it's just unfair and the court makes it up. So for example, you've got cohabiting spouses, right? One of them pays for something, they kind of agree between them verbally but not in writing because they're dumb, and they tell each other, hey, this thing, I'm buying it, but it's not a gift. Then the court, if they separate, would say it's unfair for the spouse to have half of it because it would be a windfall and it's not the intent of the parties. So the court will say, I am creating a trust that I just made up, and from the time that you bought it, although title was transferred in half to your cohabiting spouse, you held it in trust, right? So their half portion was held in trust for you such that you can get the money back. So although legal title passed, equitable title kind of never did, and they held it on your behalf. Same thing if you've got, say, spouses, married or not. If they're married, they got a marriage contract. Guy starts a business, makes $20 million. Wife, right? The contract says that they're married. Wife doesn't get anything. That's not fair, right? She stayed home the whole time. She helped him out, and that's why he got the $20 million. Although legally, the contract bars this, and the guy owns all the shares, the courts will make up something that says, from the very beginning, he held half of the shares on behalf of his wife. So two kinds of trust, equitable principles that come in to remedy inequities where otherwise the law would affect, right, a legal transfer that's thought to be unfair. So then you have the Watt case, the Thunderbird, and that's one of the only instances where the court uses these trusts to save a gift. Because as we'll see, the principle generally is that you don't. So what happens there, right? Guy's got a boat, a pretty nice boat it seems, the Thunderbird. Then he creates a document, which is not a will. It's a deed. It's a piece of paper, and he's not dying. It's not for the purpose of when he'll die, so it's not a will. And it says, I'm transferring a half interest to Ms. X. Then his conduct, 488, is consistent with that. So he tries to sell it. Then when he wants to accept an offer, he says, I'll have to talk to Ms. X Shirley, right, and see if she agrees because she's a half owner by virtue of the piece of paper. Nonetheless, other criteria make this equivocal. Her name isn't in the registry, right? And so there's evidence of an intention because you've got the piece of paper. The piece of paper is admitted into evidence. Everyone says it's legit. No one tries to say it's a fraud. So the piece of paper, again, not useless because you have three cumulative criteria again. It's useful in establishing intention. The piece of paper says he intended to transfer it to her. Therefore, it's an indication that he did. Acceptance, again, is presumed as long as she doesn't say, no, I do not want it. But you've got to have delivery. And to the extent that the guy, of course, right then in his further dealings, he said, I've got to consult Shirley because she's got half of it. Again, that's evidence of his intention. Now, we really know he intended Shirley to have half of it, but it's not delivery. There has to be delivery in some way. And because they don't change the name on the registry, because they don't change their behavior, because she used it before he signed the piece of paper, and she used it the same way after he signed the piece of paper, it is not a gift. And so the court makes up a trust, right, and says, although the legal transfer failed, there is an equitable transfer, which essentially is useful in entitling Shirley to have the half, eventually, legally. 489 at the very bottom, though, you have the default rule, which is what I said. Almost never will that happen. The courts generally are very reluctant to use the principles of equity to perfect an imperfect gift. Because, again, these are general mechanisms, right? It's called a trust, but it's really something the court made up to change the legal meaning of a transaction because ex post facto the court thought it was unfair, right? Generally, the courts won't use that to remedy an imperfect gift. Again, they're general mechanisms which apply in a lot of other contexts, like the marriage thing I just gave you. And that's ostensibly, but not necessarily, it's just me speculating, because a gift is already a modified thing for it to be fair. As we said, it's essentially a contractual transfer, you agree, that does not meet the regular contractual requirements if you're transferring personal property because there's no consideration. Okay, and the 490-91 is where you have the more specific discussion of what I mentioned to specifically label them. I'm not sure if I mentioned that earlier. A constructive trust is where the principles of equity save a legal transfer that otherwise would be invalid. And a resulting trust is where the court, as in my marriage example, just makes it up because something is unfair. Okay, then very brief 493, Calvert. discussion of incapacity. So, because capacity, as in contract law really, is not a specific requirement for a transfer of property to happen by gift, that means you don't have to specifically show capacity every time. You don't have to go to court and say, this person was not insane or this person was not a minor. So, the burden of showing incapacity, for that reason, is on the person alleging it. So, capacity, because it's not a requirement, is essentially presumed. Therefore, the burden will be on the person alleging the lack of capacity to establish it. Otherwise, it's presumed. Okay, then you have the donatio mortis causa. As I said, won't repeat it. It's a hybrid category because it's got death involved like a will, but it's a present transfer of property like a deed. It happens then and there when a person says it's yours in contemplation of their death. And it's also a hybrid category in that it's got a special right to automatic revocation in that if you don't die, you have to give it back. You have to give it back again because it was duly transferred. It wasn't a conditional future transfer, it was a present transfer. The kid got the $2 million in my example, therefore, if you want to say it's revoked, it means you have to undo the transfer and the kid has to give it back. That's how the donatio mortis causa differs from both a will and a deed. Okay, you've got an example of that in the Rizzicaria case. Same thing, right? It's a matter of whether you meet the requirements, right? Which again, so it's donatio mortis causa, and you have to meet the three things we mentioned. So it's a transfer. You still have to have intention, acceptance, and delivery. And it's a present transfer, like a deed. So intention to transfer something permanently and for free. Acceptance, namely, guy doesn't say, no, I do not want it. And delivery. It's delivered then and there because the nature of it is that it's a present transfer, unlike a will. In a will, there's delivery later, when you die, not when you write the will. Donatio mortis causa is, as we said, a present transfer like a deed, so you have to have delivery now, because the transfer of title happens in the now. So, guy wants to give someone else his money. He says, I've got money stashed under my house, I think. And it's stashed really well, no one can see it, and he tells the guy specifically how to retrieve it, and otherwise could not have been retrieved. But he says, come back tomorrow, we'll sign the piece of paper. However, that's not a requirement. So, you don't need to have a piece of paper because, right, it's personal property, therefore it doesn't apply. Then the guy dies, they haven't signed the piece of paper, someone tries to, I think, demolish the house, and he says, wait, I have to get the cash that's stashed underneath, and the question is whether or not that was duly and properly transferred. And the guy gets it because the requirements are met. First, the intention, the acceptance, and the delivery. Because by giving the instructions, he gave enough for the guy to get control, for the guy to find the money, which otherwise could not have been found. It's the only means of getting the money. He gives him the means of finding the money, therefore, it's found to be sufficient. Okay, I just want to mention something specifically, which I'm not sure I mentioned, and it's what we call the statute of frauds. It's a very old English law, which was, like other things we saw, imported into Canada through the concept of reception. And, right, once it's imported into Canada, it applies. Statute of frauds was essentially when the king woke up one day and thought there was kind of a problem with the fact that nothing needed to be in writing. Passed the statute of frauds that said when you're transferring property, it has to be in writing, a deed. Everything I discussed earlier would happen under that. Okay, we'll do some erasing again. Okay, and now we'll discuss real property specifically. So, real property, as we said, there is a requirement that you sign a piece of paper to transfer because there's a statutory requirement to do that. And that's how it differs again from a transfer of personal property. For example, a gift, so you could transfer real property for free, but you'd have to have a deed, even though the common law does not specifically require that, right? The statutory law does. Okay, usually, as is mentioned, 501 and following, the way in which you transfer real property is, so if you want to buy a house, right, you make an offer on a form, then the seller, if they're happy with the price, accepts it on a form. Then that creates a valid contract. You've got offer and acceptance. You are bound then to purchase the property for the amount that's indicated in there, subject to the conditions. So it might say, if you don't get financing, the thing is canceled. If you're not happy with the inspection, the thing is canceled. Then, if that happens, the contract is revoked because the contract says that, right? The contract says if this happens, not valid. Well, if this happens, not valid. Nonetheless, you can't just change your mind because it's a contract. So, you transfer property by deed, as we said. You go to someone's office, you sign a piece of paper, it transfers the property. That is the transfer. However, the way in which you buy a house is what I said. Before that, you have an offer and acceptance subject to conditions, so the transfer has not yet happened. That's an agreement to purchase. It's an agreement to execute a deed in the future. That's how it works. So the deed hasn't happened yet, but as I said, it's a valid contract. So you can't change your mind. You can have it revoked for the conditions provided for. That's what they're used for, right? But you can't just change your mind because you changed your mind. So what happens there, so the question is, right, do you have an obligation to sign later on the deed? And the answer is yes. In fact, that's what the contract was entered into for, right? You signed an agreement to purchase, which is an agreement to sign a deed later, so it wouldn't be a problem if it was worth nothing. So in that sense, right, it is as though you signed the deed because you entered into an obligation to sign the deed. If there's 3 exceptions provided for, like the inspection, then these are the reasons why you cannot sign the deed, right? That does not mean that there's other exceptions. So it's as though you signed the deed. Why is that? Because equitable title passes. So the courts make up something to affect that, and that is equitable title. So they say legal title hasn't passed because legal title passes by deed. Legal title being your fee simple, or property interest to your house, a fee simple. It's not passed yet, it passes by deed. By deed, it becomes a fee simple between owner number 2 and the house. Hasn't happened yet. What's the court say? To force you to execute the contract you signed, it says equitable title passes. So, you're still the legal owner, but now Mr. X, right, owner number 2, is the equitable owner, like a trust. A trust is you hold something for someone else, you have equitable title. Someone has legal title, someone has equitable title, and the someone who has legal title holds it for someone else. Trustee, in our actual trust example from, I think, 2 weeks back, trustee has legal title, it's the stuff is under their name, but it's not really theirs, right? They can't use the income from the $5 million of irresponsible kin, to use my earlier example, for their own benefit, to buy food and computers. It doesn't work that way. They cannot use it, right? And so their legal title isn't worth much because someone else's equitable title, and that someone is essentially the beneficiary of that. So you hold legal title, but you hold it to the benefit of someone else, it's someone else's equitable title. Same thing here. Owner number 2 is equitable title, and so as the owner who hasn't signed the deed yet, you legally own the house in the registry, for example, but it's not worth much because owner number 2 has a right to get it. And there are various consequences of that, right? Page 502, for example, because you have equitable title, you have to insure the house, even though you don't own it yet. And similarly, owner number 1 does not necessarily have to. Okay. Other consequence of that is specific performance. So, if it were only a contract, it would still be a contract. So say it's a contract. You sign an agreement to purchase a house. That's a contract. It's a right of a contractual nature. If that contract is not respected, so say the courts didn't make anything up, you'd have a contract that says, I agree to sell you my house. It's valid. So you can have a breach of contract. If the other party says, I no longer want to sell you my house, that's a breach of contract. They're not doing what they said they'd do in the contract. Of course, they did something wrong. You can sue them. You can sue them for a breach of contract. Go to court and say, they breached your contract. The default remedy for that is money, damages, dollars. That's what the court gives. So, if you didn't have equitable title pass, you'd still have a breach of contract that would be actionable and compensable with money. With equitable title, you pass a right of a different nature. Same thing as the license thing we talked about for a bit, right? The contract is a right of a contractual nature. You can sue for damages. If equitable title passes, title, the fee simple, so equitable fee simple passes. The fee simple is a property interest, not a contractual interest, as we said multiple times. It's a relationship between you and the thing, not between you and another person, which is what a contract is. Equitable title passes. What's that mean? It means the second party, the acquirer, acquires a property interest. They acquire equitable title, an equitable fee simple on the house. There is therefore a property interest, which is a direct relationship between them and the house. What's that mean? Well, that means they can ask for specific performance. Unlike as if there were only a contract, they can say, I don't want money, I want the house. And that's synonymous with what I said earlier. It's as though you signed the deed, because the contract forces you to eventually sign the deed, and you can't change your mind. If you change your mind, you can't even just give money. You have to give the actual house. Okay, there's a case on that. Lysick, page 505. We won't cover it because it just says what I said. And it has the insurance principles that we discussed, right? It says you have to insure the house if equitable title passes because you have a property interest. Initially, specific performance was the default remedy. So, under the common law, right, because there was equitable title, the default remedy was specific performance. So if you went to court, the question did not really get asked as to whether or not you'd get specific performance. It wasn't a right to specific performance, right? It wasn't say, if it were a contract, you'd get damages. Now, because you've got equitable title, you can ask for a specific performance. It's not how courts construed it. It wasn't you can ask for it, it was you're entitled to it. By default, if you went to court and sought something about a breach of an agreement to transfer, to enter into a deed at a later date, the default remedy was specific performance. So by default, the counterparty had to transfer the house, not give you money. Then the court, as we'll see under the Semmelhago case, blurred that. It kind of weakened the presumption that specific performance is the default remedy. Doesn't mean you don't get specific performance. This means sometimes, if the counterparty disagrees, you might not get it. And that's why you have the criterion of uniqueness. So, specific performance, the court will say, is not granted systematically because of equitable title. It's granted systematically because of an underlying policy concern, which is what specific performance was more generally made up for, because you can have it in other areas of the law, of contract law, and that is when damages are not sufficient. So, if you want to buy a house, usually you want to buy that house. If they give you money, it's no good because it's the house that you want. It's special for another reason than money. Specific performance is used to affect that, to recognize that money would not be a sufficient substitute for the house, and that you didn't just buy the house for money, and that your harm is essentially not fully compensable by money. Supreme Court will say there's no default presumption necessarily of specific performance per se, because the common law says that. Instead, we recognize that specific performance will often be ordered, but for an underlying reason, and that is the uniqueness of the property. So to the extent that it's not a unique property, that the underlying concern there of the harm not being compensable with money does not apply, then the counterparty might have the court order damages instead of specific performance, essentially. And that will happen almost always for residential properties. If it's a commercial property, usually it's more of an investment. You buy it to make money, not because it's special. That's essentially what the case law will say. So, applies again for both residential and commercial properties, usually will more often be ordered for residential properties because it's more likely that the court will order it. The court will find, that the property is unique. The case is Marvost for a residential property, page 511. Yeah, 511 essentially reiterates what I said. And you also have a kind of more detailed discussion of what uniqueness means. Basically, doesn't have to be fully unique, right? Doesn't mean that you have no substitute, that there is no similar house on the same street or somewhere else in the city. It's not that stringent of a standard. It's more relaxed. It just means that you wanted that house specifically for a reason or another, which is inherently, idiosyncratic and subjective, depends on the specific buyer, but doesn't mean that there has to be no substitute. So it's a standard in that if it's just an investment, it doesn't count, but it's a somewhat relaxed standard. One thing we'll discuss briefly, but we won't cover because we don't read the chapter on that. The moment where it becomes relevant, that you've only had an equitable transfer, not a legal transfer, is because of third parties. So an equitable transfer essentially does the same thing. So if you have equitable title passed, it's as though you signed the deed, right? Because the deed is a legal transfer, you get a fee simple. Well, if you have a piece of paper, equitable title passes, and there's a court rule that the court made up that says you have a full right to force the other party to sign the deed at a later date, it's really as though you signed the deed, right? The equitable principles are called equitable, but the end result is the same, and that is that eventually the party can and will be forced to sign the contract, the deed. It's not exactly true. The distinction between equitable and legal title is that equitable principles are generally not opposable to third parties. So legal title, whole thing, fee simple transferred in the registry, everyone's happy. One consequence of that is that the third party knows. Now the transfer of the fee simple is registered in the registry. Therefore, if the seller is a bad person, they try to sell the house a second time. It won't work because there's a land registry that says they no longer own it. So the third party, purchaser number 2, will look it up, have their lawyer look it up, and will find that the guy doesn't own the house he's trying to sell. So it won't work. It's equitable title. If it's an agreement to purchase, it doesn't show up in the registry. So it would not be fair to penalize a third party if the third party acquires legal title. So say there's an agreement to purchase. Then the guy in hiding finds a second purchaser. And with that second purchaser doesn't get an agreement to transfer, just signs a deed. Goes to the lawyer's office, signs the deed. Then the purchaser has legal title. And it wouldn't be fair to strip them of it because of equitable title when they could not know. And that's the distinction. Equitable title doesn't show up in the registry. Not only did they not know, they could not know. And so, we will leave the house to the third party. Although it is later, and the later we saw is really relevant in property law usually, right? You have a right to possession, it's opposable to future possessors, not earlier possessors like the owner. So the timing is important. Usually we prioritize the first person. That's only true for a legal title or a legal interest, like a possessory interest arising by virtue of the fact that you found a lost object. Here, legal title prevails, although legal title postdates equitable title. So, purchaser number 1 has equitable title by virtue of an agreement to transfer. Purchaser number 2 has legal title prevails. In that case, the equitable title of the person will not be opposable to the third party. It'll still be opposable to the seller, namely they can sue, but when they sue, they won't get specific performance. Specific performance would be the house, because that would mean opposing it to a third party who now owns the house, and that wouldn't be fair. And that's essentially the distinction between legal and equitable title for our purposes. There's a whole chapter on that, but right, equitable title cannot be opposed to. Oftentimes it's called a bona fide purchaser without notice. What does that mean, right? A person acting in good faith who bought it without notice. They did not know, and essentially they could not know. That's the good faith part of it. So they did not know, and good faith means they didn't know because they plugged their ears. They didn't know for a legitimate reason. Equitable title not opposable to a third party in good faith without notice, but that is just a permutation of what I said. Legal title prevails upon equitable title, and equitable title leads to specific performance, but not as opposed to anyone except the rightful owner. And that's the distinction. Equitable right there is opposable to the owner, not to the world, unlike legal title. And that will be it for this week.